Good evening, class. Since that you have already in possession of your module in criminal evidence, we will start our discussion proper on this subject. Now, under your module, the first page is all about sources of evidence. Accordingly, there are 5 sources of evidence. Number 1 is rules of court from Rule 128 to Rule 133. Number 2, the Constitution. Number 3 is special laws like Anti-Wiretapping Act and other special laws that provide rule on evidence. And number 4 is revised penal code, civil code, and other kinds of laws or public laws. And number 5 is jurisprudence. The highlights among the sources of evidence is the first two, the rules of court and the Constitution. Now, what particular provision of the Constitution that provides sources of evidence? The provision of the Constitution that provides rules or sources of evidence is found under Article 3 of the Constitution, particularly Section 1, Section 2, Section 4, Section 12, Section 17 of the said article. Section 1 of Article 3 states that no person shall be deprived of life, liberty, or property without due process of law. Now, this is a general principle of due process, that the life, liberty, and property of any person cannot be deprived without strict observance of due process. In the observance of due process, it is necessary that the one being charged of a criminal act must be afforded with sufficient opportunity to present his or her evidence to defend himself. If that opportunity was not afforded to the accused, then there was no strict observance of procedural due process, and it may be the basis to invalidate the entire proceedings, and any decisions, either decision of acquittal or decision of conviction, is ineffective and invalid because of non-observance of procedural due process. Another provision under Article 3 is Section 2. It deals about the issuance of search warrant, the requirements of the issuance of a search warrant. And it is also deals with the right of the accused or right of any person against unreasonable searches and seizure. That the right of the people or the right of any person to protect his person, papers, and effects against unreasonable searches and seizure shall be inviolable. In other words, if there is a search or seizure conducted on his body or in his premises without strict observance of the said without strict observance of the rule or of his rights, any evidence obtained from him would be inadmissible in evidence. When we speak of inadmissibility of evidence, the said evidence does not conform with the prevailing rule relative to searches and seizure. Now, Section 2, Article 3 provides a rule that the body or premises of a person cannot be subjected to search and seizure without a valid search warrant. So in the absence of a search warrant issued by the court, generally any search and seizure conducted by the law enforcement agency is considered as invalid search, and therefore any evidence obtained during the search will also be considered by law as invalid, and therefore it cannot be utilized as an evidence against the accused or against the respondent, because these are evidence that called as incompetent evidence, because in the obtaining of the same there was a serious violation of a constitutional right of the accused or of the respondent as provided under Section 2 of Article 3 of the 1987 Philippine Constitution. However, the rule is not absolute. The rule is not absolute, considering that the law allows some exceptional cases. In other words, the law allows warrantless arrest, a warrantless search rather. In other words, even if there is no search warrant issued by the court, in some exceptional cases or circumstances, law enforcement officer is allowed or are allowed to conduct search, and this is called as valid warrantless search. Now, what are those exceptional cases or circumstances allowed by law? Allowed the law enforcement officer rather to conduct a search. 1. Search incident to a lawful arrest. search incident to a lawful arrest. What is meant by this exception? The search is only incidental to a lawful arrest. In other words, the arrest conducted was ahead of the search, and it must be necessary that the arrest must be valid, so much so that the subsequent search will also be considered valid. In other words, the warrantless search conducted on this particular exception would depend on the arrest conducted. So if the arrest conducted is invalid because it does not comply with the requirements of the law, then the search is also invalid. But if the arrest is valid because it complies all the requirements of the law in the conduct of the arrest, then the subsequent search conducted in his body or in the body of the accused will also be considered valid. Now, how can we determine that the arrest is valid? Under the rule, there are two modes of arrest. Number one, by virtue of a valid warrant of arrest. Now, take note, a warrant of arrest will only be issued by the court if there is already a case filed before the court and the court or the judge who handled the case already determines the existence of a probable cause for the issuance of a warrant of arrest. So if there is already a warrant of arrest issued by the court, it means that there was sufficient basis in the filing of the case in court. So if the accused was arrested by virtue of a warrant of arrest, of a valid warrant of arrest, then the arresting officer is allowed under exceptional cases to conduct a body search or a search of the body of the accused, and does not need search warrant because the search conducted on the body of the accused is an incidental to a valid arrest by virtue of a valid warrant of arrest. The other mode of arrest is warrantless arrest. In this particular mode of arrest, there was no warrant of arrest issued by the court. Instead, the accused or the suspect was arrested without warrant. But the arrest is valid because at the time that the accused or suspect was arrested, he is committing or actually committing or in attempt to commit an offense, otherwise called as or other term of which is arrest in flagrante or caught in flagrante. So if a person subject of the arrest committed a crime or an attempt to commit a crime or an actual commission of the crime in the presence of peace officer or any person, the same would be a valid basis for the conduct of warrantless arrest. And if he was already arrested, or if the accused was already arrested by virtue of a warrantless arrest, then subsequently search will be conducted on his body, and that search is called as search incident to a lawful or valid warrantless arrest. Another exceptions, before the next exceptions, whatever evidence, whatever illegal item seized from the body of the accused or of the suspect after he was arrested lawfully, either by virtue of a warrant of arrest or by warrantless arrest, may be utilized or may be used as an evidence against him. And that would be admissible in evidence because that's the fruit of a valid search. Okay, the next exception to search warrant is checkpoint. Checkpoint as an exception to a search warrant is limited only to eye search. In other words, the law enforcement officers conducting the checkpoint has no authority or is not authorized to touch anything inside the motor vehicle. He is only entitled to see anything inside the vehicle, but he has no authority to touch anything thereat or to find anything inside the motor vehicle. That is the limitation of checkpoint. So if there is an illegal item inside the motor vehicle and it is apparent or visible to the eye of the law enforcement officer conducting the checkpoint, he is entitled to search and seize that illegal item visible to his eye, and it may be used as an evidence against the possessor of the motor vehicle or of the driver himself. The next exception to search warrant is maritime search. All sea vessel either for passengers or cargoes is or are subject to maritime search to be able to determine whether there is a violation of maritime laws. So the owner of a motor bangka or a sea vessel cannot resist on the search conducted by maritime police even without a search warrant, because the same is an exception to search warrant for purposes of implementing or enforcing maritime laws. The next exception is custom search. All goods all imported goods or anything coming from a foreign countries are subject to custom search to be able to determine whether there was sufficient compliance of tariff and custom code. In the enforcement of tariff and custom code, our Bureau of Customs is mandated to conduct search of unimported goods or any item coming from foreign countries to determine whether there is sufficient payment of the tariff fees and other duties. So to be able to know the same, to be able to determine the same, if indeed there was sufficient compliance of the payment of tariff fees and duties, search of those items must be made and no need of a search warrant. The next one is stop and frisk. The body of any person who is entering a public establishments like malls and other similar establishments are obligated to surrender themselves for the conduct of body frisk or body search for public safety purposes, and there is no need of a search warrant. Another exception is plain view search. When we speak of plain view, it is open to an eye search or open to anyone's eye. However, the law provides two kinds of plain view. One is open to an eye search, and number two is incidental search or inadvertent search. In an open to an eye search as a kind of plain view search, the police officer has no any intention whatsoever to locate or to see or to find that item. By a mere glance, he see it, and according to him, the said item is an illegal item, so he can search and seize it even without a search warrant. However, there is an indispensable requirement to make plain view search or open to an eye search becomes valid. The intrusion of the police officer or of the law enforcement officer in the place where that illegal item is located is valid. So therefore, if the intrusion of the police officer in the place where that item is located is invalid, as if he has no any authority to intrude to that place, then even if the item is open to his eye, and even if he searched it, he cannot utilize it as an evidence against the owner considering that the search conducted or the open to an eye search conducted by him is invalid, considering that his intrusion in the place is invalid. Another kind of plain view search is incidental search. Again, the valid intrusion of the searching officer or police officer is valid. The intrusion in the place where that item was found or located must be valid. Now, unlike in the first mode of plain view search, in this kind of plain view search, so-called incidental search, the police officer validly intruded in the place, has business in the said place, to be able to locate item or items that are subject to search. In other words, there is a search warrant and he is serving the search warrant